I'm Dyke Davis, and my co-chairman Yoon Young Lee and I would like to welcome you on behalf of the Board of Student Advisors to the 76th annual final round of the Ames Moot Court competition. Presiding over the competition this evening will be the Honorable Antonin G. Scalia of the Supreme Court of the United States, the Honorable Dorothy W. Nelson of the United States Court of Appeals for the Ninth Circuit, and the Honorable Sam J. Ervin III of the United States Court of Appeals for the Fourth Circuit. Justice Scalia will be acting as Chief Justice this evening. The cable television network C-SPAN is filming the events tonight, and it will be shown sometime over the weekend, but they're not sure when, so just look for your local listings and you can see it. After the argument this evening, we'll be having a reception in the John Chipman Gray Room over on the second floor of Pound, and we'd be honored if you'd all join us there to celebrate the events this evening. I'd like to remind any cameramen in the audience that there can be no use of flashes during the argument. Again, welcome to the final round of the Ames competition, and we hope you enjoy the evening.
Before the Honorable, the Supreme Court of the United States, draw near and give attention, because the court is now sitting. God save the United States and this honorable court.
The case we have before us today is Fletcher versus Hermann, number 87531. Counsel for petitioner ready? Proceed.
Mr. Chief Justice, and may it please the Court, my name is Mark Batten, and with Robert Gerber, I represent the petitioner in this action, Mr. Alvin Fletcher. There are two issues before the Court. First, I will argue that the statements appearing in Mr. Fletcher's column, which Professor Hermann here challenges as libelous, are absolutely protected under the First Amendment. Mr. Gerber will argue that even if the statements are not so protected, Professor Hermann as a public figure has failed to prove actual malice by Mr. Fletcher, and that therefore the District Court's grant of summary judgment was nonetheless proper. The facts briefly are these. Professor Hermann is a well-known radical...
Mr. Batten, you've divided your time with your co-counsel.
That's correct, Your Honor.
The clerk knows.
Yes, sir. Professor Hermann is a well-known radical professor of political science who was nominated to chair the political science department at Ames University. After news reports indicated that his nomination was likely to prove controversial, Mr. Fletcher devoted one of his syndicated columns to the nomination. He argued that the debate surrounding the nomination was wrongly focused, that instead of criticizing Professor Hermann for his Marxist beliefs, the public should instead consider Professor Hermann's intentions for the department if his nomination were confirmed. Based on his readings of Professor Hermann's works, interviews with Professor Hermann's colleagues, Ames University faculty, and students, Mr. Fletcher argued in his column that Professor Hermann, if confirmed, might use his position as department chair to influence students with his radical beliefs. Professor Hermann brought this libel action, claiming that 5 sentences in Mr. Fletcher's article defamed him. The district court granted summary judgment, finding that Professor Hermann was a public figure and had failed to prove actual malice. The Ames Circuit reversed, finding both that Professor Hermann was a private figure and that Mr. Fletcher's statements, even if opinion, should not be absolutely protected because Mr. Fletcher had failed to provide enough facts in his column to justify his conclusions. In addressing the fact-opinion distinction, the basic disagreement between the parties is how careful courts should be about protecting opinion from liability in libel cases. Mr. Fletcher argues that all opinion should be protected, even if some false speech is swept into that circle of protection. Professor Hermann, on the other hand, argues that a statement that's even arguably factual should go to the jury, and thereby allows juries to impose liability on statements that might actually be read as opinion. In reaching this disagreement between the parties, we begin with the common ground. Under the First Amendment, as the court said in Gertz, there is no such thing as a false idea. And the essential characteristic of speech that strips it of its constitutional protection is falsity. Expressions of opinion, because they describe the subjective beliefs of a speaker, cannot be false. And therefore, there can be no liability for opinion.
Mr. Batten, this court in the Gertz case said that there is no constitutional value in false statements of fact, did it not?
It did, Your Honor.
How do you square that with what you're saying to us?
We absolutely agree with that position, Your Honor. Any statement that is a false statement of fact it deserves to be held liable by a jury. But before we can reach that conclusion, we have to first determine that the statement is both a fact and that it is false. And the issue I'm addressing at this point is how courts at summary judgment should determine whether the statement is a fact or an opinion in the first place. We would argue that based on Hepps, which held that a plaintiff at trial has to prove the statement's false, at summary judgment, a plaintiff, like any civil plaintiff, must show that a reasonable jury could find for that plaintiff. And because no reasonable jury could impose liability for opinions, Professor Hermann must demonstrate at summary judgment that the statements challenged are not opinions. The parties agree that this capable of being proved false is the proper inquiry at summary judgment, but they disagree about the substantive content of that standard.
Well, let's get right to the heart of it then. One of the most difficult parts of this case is the statement by Mr. Fletcher that Mr. Hermann has no status in the profession. I think that's really one of the most difficult parts. Don't you think that the question of whether or not someone has status in a profession, such as a political scientist, is verifiable and therefore should be deemed to be a fact?
There is certainly a factual interpretation that might reasonably be drawn out of that statement, Your Honor, and as we conceded in our brief, that's one of the 5 statements that could be interpreted as factual. But it's also interpretable just as reasonably as a statement of opinion. Status is not an objective fact. It depends on who you ask, and the record demonstrates this.
Well, if it can go either way, why don't you let a jury decide?
Juries, Your Honor, cannot be trusted to do the fact-opinion distinction for both constitutional and procedural reasons. On the constitutional side, as this court held in Bose Corporation versus Consumers Union, where a plaintiff seeks to place statements within the narrow categories of unprotected speech, like obscenity, fighting words, or libel, courts have to be especially critical to be sure that no protected speech falls within those narrow categories and to ensure that they, in fact, remain narrow. The procedural reason is that our basic position is an application of traditional summary judgment principles to the holding in Hepps. To allow this sort of determination, which we admit is a difficult one, to go to the jury, essentially says that just because, even though the plaintiff's case is not sound as a matter of law, Nonetheless, we should allow the case to go to the jury to decide whether it's a fact or an opinion.
I don't understand that. You say it's not sound as a matter of law, but you're equating the issue of law with the factual determination that the jury is supposed to make, aren't you?
We are,
You're saying that the facts have to be adjudicated by the court at the summary judgment stage.
Not the facts, Your Honor. Determining whether the statement is actionable fact or protected opinion is a question of law for the court. And I understood Justice Nelson's question to ask why the jury couldn't make that sort of a determination. And it's not only for the constitutional reason, but also because we believe that showing the statement to be not opinion is the same sort of threshold test that any plaintiff has to meet in a civil case. Because if it's an opinion, it can't be proved false. And so no reasonable jury could find for the plaintiff.
You say if it's an opinion, it can't be proved false. Do you also agree that if it can't be proved false, it's an opinion?
No, Your Honor. There are certainly statements of fact that might be unprovable.
What is your criterion for whether it's an opinion?
The basic test that we set out in our brief, Your Honor, there are two factors that courts should consider. If a statement is vague, like calling someone a fascist, or if it depends for its truth on the subjective values of the speaker. If either of those tests are met, then the statement is an opinion. If both of those tests fail, then it's a statement of fact.
Now, why is the assertion that this man has no status in his profession? Why does that fail under either one of those tests?
It doesn't, Your Honor. That's the one statement where both the vagueness and the subjectivity inquiries are inconclusive, because there's a readily available factual and opinion interpretation for that statement.
Well, if it's inconclusive, I would think that it goes to the jury then. You don't decide it on summary judgment.
Your Honor, what we've argued in our brief is that when it is inconclusive under those two factors, then courts should look to context to determine which of the two reasonable interpretations is the correct one. But it still can't go to the jury because it's still essentially a matter of law. We can't let juries consider whether a statement is fact or opinion because the plaintiff simply hasn't met the burden of showing that it's not.
Isn't the real question whether a reasonable person would believe it to be true? And if your test is correct, that we look to context, we look to all the other things that even a liberal thought he had no status, and all the other things that were said in Mr. Fletcher's article, if we're looking to context here, doesn't this come out in favor of Professor Hermann?
We don't believe so, Your Honor, because
Why not?
Because there's much more context pointing in Mr. Fletcher's direction. Almost every statement in the article, aside from the ones challenged by Professor Hermann here, is shot through with exaggerated rhetoric, terms like academic prince valiance, McCarthyite know-nothings, justified chastisement. The article appeared on the op-ed page of a newspaper and concerned a public controversy that was going on in Ames.
Well,
So
I don't understand. You mean so long as you make a lot of exaggerated statements in the course of a libel, you can get away with anything? I mean,
not at all, Your Honor.
Just throw in eight exaggerations and then say, moreover, the man is a child molester. Then that's all right. I mean, you can tell from the rest of the context that this fellow's a congenital exaggerator. So.
No, Your Honor, that's precisely the reason why Mr. Fletcher's test confines context to the very narrow instances where the vague and subjective tests are inconclusive. Professor Hermann's test, in contrast, begins with context, begins with what Justice Nelson and I have just demonstrated is a very flexible analysis, and context often cuts in both directions. That may be why Professor Hermann's test starts with context, because it allows him to draw the factual interpretation that he wants to draw.
Well, without being accused of having demonstrated something, let me ask you one more question. Does it make any difference here that we're dealing with a political science professor, that we're talking about political debate?
It may, Your Honor. We don't believe that the case depends on the fact that it's political speech. But it's true that those who speak on political issues should expect a little bit more derogation and a little more criticism than others. But by no means would we argue that Mr. Fletcher's speech is somehow immune because the issue is political. As long as it's an issue of public concern, that's enough under our test.
Is public concern enough, or does it have to be public controversy?
It has to be a public controversy for the public figure section, Your Honor. But as this court held in Heps, public concern is sufficient for the fact-opinion question, for the falsity question. And because this is an issue of public concern, as Mr. Gerber will argue more fully, this court, like the court in Heps, need not reach the more difficult issues of what happens when the statement is on questions of private concern. Thus, Mr. Fletcher's test, which looks to this vagueness and subjectivity inquiry, grows out of the basic presumption that all speech is protected until the plaintiff can prove it false. And the idea that has appeared in this court's opinions from New York Times on down, that we must guarantee that we protect.
You're not giving him a chance to prove it false. You want judgment at the summary judgment stage. Are we to give him his full chance to prove it false at summary judgment?
Your Honor,
in that case, you may as well not have summary judgment. You have a full trial all the time.
It wouldn't be a full trial, Your Honor, because the falsity issue is much more narrow. There are two things that the plaintiff has to do under our test at summary judgment. Before he gets a chance to prove it false, he must demonstrate that as a matter of law, it's a statement that's capable of being proved false. And then, once he's met that burden under the vagueness and subjectivity test we've proposed, then all he would have to do is show that he's got enough evidence that a reasonable jury could find the statement false.
All right. Now, why is it not capable of proving the falsity of the assertion that a particular individual has no status in his profession?
Because we believe, Your Honor, that when taken in context in this hard case, the statement would be read by the average reader as opinion. That's the basic conclusion that both sides are trying to reach. What would the average reader interpret the statement to be, fact or opinion? And a statement that seems subjective...
He didn't say, I think he has no status. He didn't even say, I think he has no status in his profession. He said, according to. He put the words in the mouth of someone else. Why would you do that if you're trying to convey your own opinion?
Opinions, even though they are opinions, are more persuasive, perhaps, if you can find someone else, a respected other person who also...
If you assert them as facts, yes.
Well, but
if you assert them as facts, you're subject to a libel suit.
That would be one persuasive way to do it. Another way to make your case persuasive is to find someone else, a respected colleague of Professor Hermann's, who has the same opinion you do, and to present it in your article. And the fact that he quotes someone else, though maybe an element of context suggesting that it's factual, is not determinative. Professor Hermann's test is constitutionally defective as compared to Mr. Fletcher's test because it's so flexible that almost every statement that a speaker could possibly make will go to the jury. If they can concoct any factual interpretation, then the statement goes to the jury. It's a completely standardless analysis. Though they argue in their brief that the average reader would interpret the statements to be factual, that's not an analysis, that's not a test. That's the conclusion that both sides are trying to reach, and nowhere in their brief do they offer an explanation of how, beyond the facts of this case, judges are supposed to decide this question.
I'm not sure that yours is very different. I'm not sure that yours is very different from theirs. It comes down to both, on both theories, it comes down to whether this, let's just take that one particular statement about status in the profession, whether it is reasonably received by those to whom it's addressed as an opinion or as a factual statement. Isn't that what you're both after?
It is what we're both after, Your Honor. And neither test claims to be precise, mechanical, and there's no claim that either test is going to produce perfectly consistent results between judges. But Mr. Fletcher's test at least makes an attempt in the vagueness and the subjectivity categories to confine district court's discretion a little bit. Professor Hermann's test would deprive almost all speakers of summary judgment because the only speech that would be thrown out of the case at summary judgment under their test is the purest, exaggerated rhetoric.
What is so really wrong with that? If you consider that a jury is supposed to be made up of reasonable persons acting reasonably and thinking reasonably, and your test is what a reasonable person would think Mr. Fletcher was saying, why shouldn't we let it all go to the jury?
For the same reasons that I mentioned before, Your Honor. It's because the statement might actually be a statement of opinion, that sending all the statements like that to the jury would allow juries to impose liability for opinion. And that compromises the absolute protection that this court has stated over and over again.
But isn't that what we customarily do when we apply a reasonable man standards? We let the jury say what the reasonable man does?
On questions of fact, Your Honor, we certainly do. But here, this is a question of law. It's a question of the scope of constitutional protection.
That's what you keep telling us, but at the same time, I'm troubled as my colleagues are about the statement, no status within his profession.
Let me address that statement more directly then, Your Honor. First of all, there is a subjective interpretation that could be drawn from that, an opinion interpretation that readers might find in that statement. Status, as I was arguing before, is not an objective fact, but depends on who you talk to. Professor Hermann points to an opinion poll in which he was ranked 10th in the profession in terms of occupational prestige, but at the same time, he came in twice. On 2 occasions, he came in...
Status doesn't depend on whom you talk to. I mean, if you talk to 100 different people, 100 of them will give you different answers, but you can add up the answers and finally conclude that he has status. 70 of them think he's a heck of a professor. 30 think he's not very good. The mere fact that they differ one from another doesn't mean it's not provable whether the person has status or not. Isn't that right?
But then most opinions, Your Honor, would be provable under that standard. That's the sort of analysis I think that Professor Hermann is suggesting, because a factual interpretation could be derived even though everyone holds a different belief on the issue. Moreover, the fact that Mr. Fletcher's statement says he has no status in the profession is so absolute that it can reasonably be read as exaggerated rhetoric. To say that
I think you're eating into your colleague's time, if you don't intend to do that.
No, Your Honor, there's 2 minutes.
2 minutes after the red light? Fine. Give him 10 extra seconds.
Thank you, Your Honor. In sum, there are 2 basic categories of problems with Professor Hermann's test that Mr. Fletcher's test avoids. First, because their burden is so low in proving that a statement is factual and should go to the jury, they essentially shift the burden back to the defendant at summary judgment to show that the statement fits in the narrow category of pure opinion. And that's exactly the sort of burden shift that this court rejected in Heps.
Your thesis is that somehow you can't let go to the jury any element of whether the speech is protected or not.
That's
so
right.
You would not let go to the jury whether particular words are fighting words. The jury can't decide whether they are the kind of words which in the context are likely to provoke someone to violence. That can't be a jury question at all.
No, Your Honor.
If there's any doubt about it, if a reasonable jury might find it that way, but another reasonable jury might not, it can't go to the jury at all.
No, Your Honor, because...
Obscenity, the same thing, whether it is contrary to prevailing community standards of decency and whatnot, that if it's at all doubtful one way or the other, it can't go to the jury at all.
I would say no for the most part, Your Honor, because...
What is there a right of jury trial for? This was in federal court, wasn't it?
Yes, it was, Your Honor. But
What's left to the right of jury trial in libel cases?
no court has ever held that the right of a jury trial precludes summary judgment. And if Professor Hermann can't meet the threshold showing that these statements are factual, then he doesn't deserve to go to a jury, because that allows juries to punish opinions simply because one of the 100 interpretations of the statement might appear to be factual.
But it also prevents them from doing anything to someone who makes a false statement.
Yes, it does, Your Honor, but that's the reverse presumption. That's suggesting that we should punish all false speech, even if that includes some protected speech within its scope. And the clear statement of this court's precedence has been, we protect all true speech, even if that encompasses some false speech. I see my time is up. Thank you.
Mr. Gerber?
Mr. Chief Justice, and may it please the Court. My name is Robert Gerber, and together with co-counsel Mark Batten, I represent the petitioner in this action, Mr. Alvin Fletcher. I will address 2 issues this evening. First, I will briefly argue that the Ames test and the respondent's verifiable message test unconstitutionally usurp editorial judgment in violation of this Court's reasoning in Miami Herald versus Tornillo. Second, I will explain why Professor Hermann is a public figure for the limited purpose of comment on his nomination to chair the Department of Politics and Government at the state-run University of Ames.
Before you go further, do you contend that Hermann is a public official?
No, we do not, Your Honor, and we haven't addressed that in our brief, and by such, we concede that point. But as you will see through our argument, there are many indicia of making him a public official which add to our public figure argument. Now, my co-counsel has explained...
You first told me you did not contend that he was a public official,
correct.
And then you almost said you contend he was.
Now, we will demonstrate that many of the factors that might have gone into a public official analysis help us in our characterization of him as a public figure.
All right.
My co-counsel has explained why the Ames test and the respondent's verifiable message test are constitutionally defective and that they reverse the presumption that all speech is protected. He also pointed out how standardless the verifiable message test was. Yet both of these tests suffer from another constitutional defect, and that's the fact that they allow courts to usurp editorial judgment by, in effect, telling writers and commentators like Mr. Fletcher what to print. Now, in our first brief, we demonstrated how the Ames test tells Mr. Fletcher what to write. It forces him to publish pertinent or supporting background facts along with his otherwise valid opinions. The respondent's verifiable message test has a similar but in effect opposite conclusion, and that is it forces writers and commentators to only publish exaggerated rhetoric, in effect to self-censor their own opinions in order to prevent trying to get any sense of a factual implication out of those statements.
But aren't you ignoring what the problem is here? We're talking about two kinds of free speech. The free speech of academics, not to be chilled in their statements to a classroom or on a university campus, as opposed to the free speech of the press to print what it wishes to print. We're talking about false statements, are we not? Or allegedly false statements about an academic.
That's correct, Your Honor. Let me give you a brief overview of our framework of our analysis, and then I'll address your question. Our framework first looks to see if the fact-opinion distinction has been made by the court as a matter of law. If it's opinion, it is not held to be liable. If it is factual, then this court said in New York Times and has said throughout the precedents, including Gertz, that we must then look to see what the requisite degree of fault is. And in this case, that requisite degree of fault is determined by whether or not Professor Hermann is a public figure. If he is a public figure, then the actual malice standard applies, and he has to make a stronger showing on summary judgment and at trial. Now, your question concerns the right of an academic to make his free speech as opposed to the
Let me just ask you, do you think all academics are public figures?
No, I don't, Your Honor.
How do you distinguish between a chemistry professor and a political science professor?
Well, there are two major distinctions here. The first is that Professor Hermann has published views which are directly intertwined with his ability to be department chair of politics and government at the University of Ames. He has advocated the use of a position of authority to, as some of his students and colleagues see it, transform the ideologies of the students and colleagues. Now, what we assert is that that publication is not just academic speech. That's, in a sense, also political advocacy, and it's directly related to his nomination here.
Is it because of his radical views?
No, it has nothing to do with his ideological slant, Your Honor.
Is it based on the content of his writing?
It is to the extent that he has advocated a use of a position of authority and is now being nominated to one.
Are we permitted to pick and choose among his writings or the writings of any academic?
No, and this court has said unanimously in the Mosley case, for example, that we don't want to look to content regulation and suppress speech only based on its content. The only reason that content is significant here is that it is intertwined with this nomination. It is not. It doesn't matter what his ideological slant was. When he was writing as a person advocating the use of this position and then becomes nominated to that position, we suggest that that becomes a thrusting to the vortex of a public controversy. Now, I'd like to briefly address that issue, that we believe there was a public controversy here, and it's public.
Before you get to that, let's talk a little more about self-censorship, which you say is the vice of the test that the respondents would use here. I must say, any test you adopt is going to create self-censorship, isn't it? If self-censorship is an evil.
To a large extent, that's true.
Entirely, it's true. Everybody will try to avoid libel law. Is that bad?
No.
I thought the object of having a libel law was to induce people not to libel other people.
That's exactly right.
Through their self-censorship.
That's exactly correct.
Well,
the purpose of a libel law is to prevent defamatory statements of false fact. And what some tests may do is not just prevent that, but in over-encompassing, prevent the actual expression of otherwise valid opinion. As this court said in Miami Herald, when it struck down a Florida statute that would force newspapers to publish rebuttals of political candidates, it said we must take into account that forcing them to publish these rebuttals is also forcing them to bear the costs and to bear a penalty of extra space, etc. And not only that, but it'll chill expression. By not wanting to have to publish these extra rebuttals, this extra space, incur these costs, newspapers will withhold their opinions. So the test has an overburdening effect. It goes beyond false and defamatory speech and infringes upon otherwise valid expressions of opinion.
And any test does that. Any publisher is going to try to stay well clear of the line of libel, isn't he?
He's going to try, Your Honor. But he's also going to be able to try to publish his opinions if they are valid opinions that aren't defamatory and not have to prove that they aren't defamatory in his own column. Or furthermore...
No, he doesn't have to prove. It's the other side that has to prove that they're false.
Under the Ames test, Mr. Fletcher would have to prove in his very article, he would have to parade a number of facts around that would justify his conclusions. We assert that that is in effect forcing him to prove the truth of his opinion or the reasonableness of opinion.
It depends on what his statement is. Now, let's take the example that respondents give in their brief, which seemed to me a quite reasonable one. The statement that X is a murderer, all by itself, would appear to be libelous. Would you agree with that? If I just go up to you and say, you know, the neighbor that just moved in next to you, he's a murderer. Are you aware of that?
If we were looking at this under our test, on our fact-opinion analysis, we would first say, is it so vague and subjective that it's not capable of being proven false, and say, there is a distinct factual meaning there. Then we would look at context. Now, if
you're going to answer my question?
Yes, I am. And
is that libelous or not?
It depends on the context in the final analysis.
I told you the context. Somebody just moved in next door, and someone comes up and says, you know, I know this fellow that just moved in next door. Are you aware that person is a murderer?
In that context, there is no indication that he meant anything besides the fact that that person killed somebody else. And we would hold that's libelous.
All right. Now, the example that was given in respondent's brief was that it wouldn't be libelous if the person came up to you and said something to the effect that that person was engaged in a quarrel with her husband. Mm-hmm. The husband came after her with a knife. There was a gun near at hand. She pulled out the gun, shot the husband. That woman is a murderer. Mm-hmm.
And
would that be libelous?
We might come out differently than the Ames court did and say that that potentially could be libelous. Not because there has been a sufficient number of facts paraded there, but the context was that this person had asserted that this person killed another person and committed a criminal act. And whether that criminal act is capable of being defined or not, it is, and we can say whether or not that person's a murderer.
No, but the point is that the additional facts make it clear that what you mean by murderer in the second example is not literally a person who has unlawfully, maliciously taken human life. And you say that to change the outcome on the basis of those added facts is somehow to make the publisher publish more, contrary to Miami Herald.
To the extent that we force them to make context sufficient so that we say the statement is capable of being an opinion, then yes, we are forcing them to publish facts. If they have an otherwise valid expression of opinion, that's a hard case because that could go either way. The person can use murderer figuratively. For example, if the governor had passed a regulation which eliminated a species of fish and somebody called them a murderer, that's possible that that's just an opinion based on the fact that this regulation went through. But when we nail it down so specific to murderer, it does depend on context, and we can't force an otherwise valid opinion, and that one wouldn't be. But we can't force an otherwise valid opinion to have accompanying background facts in a statement, in a newspaper article, as this court held unanimously, I might add, in Miami Herald. Now, I see that my time is limited, and I'd like to address quickly the public figure analysis because it is an important part of this case. First, I will argue that there is a public controversy here, and secondly, that Professor Hermann is at the vortex of that controversy. Because of these two things, the danger of chilling protected expression, or even low-value speech in this case, that danger weighs more heavily than any harm to the reputational interests Professor Hermann might have exhibited.
You suggest in your brief that Professor Hermann initiated the debate which prompted Mr. Fletcher's comments. Would you tell me how?
By two major things. He played both a role as a commentator on the role of a position of authority in political advocacy and education, and then as a candidate by being a nominee to an important position in Ames, the state of Ames, where he could use that or put those views into effect.
Suppose he hadn't been the candidate for the position, would that have altered the way this case should come out?
It would have been far different, Your Honor, and it would have been far more like the Hutchinson case, which respondents rely heavily on. There, the professor in Hutchinson versus Proxmire was not nominated to any position, but even more strikingly different was the fact that he hadn't advocated anything in the public controversy, which was the proper use of public expenditures. Here, not only is there a nomination, but the fact that Hermann has advocated the use of that position in a way which some people find controversial, and as newspaper reports said, it was likely to prove controversial.
But here is, in this case, very similar to Hutchinson in that he lacked access to the public. Here, Mr. Fletcher, your client, published in a nationally syndicated column. Professor Hermann could only reply in a local newspaper, and in fact his reply was, although it was on the op-ed page, which I'm sure you're going to argue is one sign that it was merely opinion as opposed to fact, but nonetheless it seems to me very similar to the Hutchinson case in terms of limited access to the public by Mr. Hermann, Professor Hermann.
That's true. In Hutchinson, what the court was concerned about was the defendant bootstrapping their argument by saying, look, the plaintiff has access to the media because he responded to this allegedly defamatory statement. What we argue is that the response to our defamatory statement was published prior to our article. And the fact that Professor Hermann published his views.
One letter to an editor in a little local newspaper be an effective channel of communication?
Certainly not, Your Honor.
You'd be better off if it was in USA Today.
That's correct. But we can't go so far as to say that a libel plaintiff's access to the media has to be equal to the defendant's, because otherwise a nationally syndicated columnist...
It certainly isn't in this case.
That's correct. And a nationally syndicated columnist is not going to write about anybody else but a nationally syndicated columnist. Now, we do say that the channels of communication here are effective in the sense that Hermann complains of harm to his reputation. And here he was able to talk to his peers through the academic journals. He was able to publish a letter in the Ames University community, which responded. And though his access may have been limited, and we agree it's not anywhere near as extensive as Mr. Fletcher's, that issue is not dispositive in terms of a public figure analysis.
But Mr. Gerber, this man wanted to be chairman of a department in a state university. He was not selected, was he?
That's correct.
He'd been nominated, he'd been approved by the chancellor, and then this article was published, and he didn't succeed.
That's correct.
How do you account for that?
We don't think that the plaintiff has shown or needs to show at this stage any causal relationship. Now, it's true from the record that when the chancellor has nominated somebody, that the president almost always supports that nomination. But we believe that there are other factors that could have happened. His colleagues who didn't respect him may have had a voice with the president. It certainly wasn't somebody out in Los Angeles, for example, reading Mr. Fletcher's column.
Well, there's nothing in this record to support that assumption on your part, is there?
Nothing directly, but there's nothing to support the assumption that the cause of that nomination not being following through on was due to Mr. Fletcher's article either.
Yes, but you're the one that wants summary judgment.
That's correct, Your Honor, and this court has to construe all the law and facts in favor of the non-moving party. But what we argue is that Professor Hermann's reputation is resilient enough from his... I see that my time is up. I'll just briefly conclude. Professor Hermann's reputation is resilient enough to withstand this article by Mr. Fletcher, and that we can't always look to courts to have them redress an injury which otherwise is going to be effectively addressed by just sheer academic and other speech in the community. Thank you.
Counsel?
Mr. Chief Justice, and may it please the Court, My name is Greg Friel, and I represent the respondent, Professor Andrei Hermann. My colleague, Lee Schott, and I will be presenting two arguments tonight in support of affirmance of the Court of Appeals judgment. First, I will argue that all 5 statements that form the basis of Professor Hermann's defamation action are actionable statements of fact rather than absolutely protected opinion. And then my colleague, Ms. Schott, will argue that Professor Hermann is not a public figure for purposes of this case. The proper way to distinguish expressions of opinion from statements of fact is to apply a 2-step analysis, which we have labeled the verifiable message test. This test requires the court to examine the alleged defamatory words in their entire context to determine the meaning that those words would convey to the average reader, and then to determine whether that meaning is objectively verifiable, that is, whether it could be proved true or false by an objective standard.
Mr. Friel, may I ask you a preliminary question?
Yes, Your Honor.
Even assuming that everything you say is true, the statements are false, that Mr. Hermann is a private figure, how do you get beyond summary judgment? You submitted no affidavits. You have no discovery. There is nothing in the record because you have to, on summary judgment, do you not submit sufficient evidence to get by summary judgment?
Your Honor, if the plaintiff, if the defendant, the petitioner at the district court level, had moved for summary judgment on the ground that there was not a genuine issue as to falsity, then Professor Hermann would have been on notice that he needed to submit opposing affidavits to address that issue. But Professor Hermann did not need to submit opposing affidavits in order for this court to deal with the fact opinion issue. The petitioner argues in its brief that summary judgment is appropriate because there is no genuine issue as to falsity, but that issue is not before the court and it has not been raised. And if the petitioner wishes to raise that at the district court level on remand, then the petitioner may do so.
It's a good answer, thank you.
The court must examine the entire context in which the words appear. And in context...
Mr. Friel, this test you're giving us is not the test that you won on below. I mean,
No, it isn't, Your Honor.
what would you sell the Court of Appeals one test for, and then you come to us with another one? You might have to appear before that court again.
Your Honor, the reason was that the reasoning of the Ames Circuit, as the petitioner points out, some of the rhetoric in the Ames Circuit approach is constitutionally defective because the Ames Circuit would not accord absolute protection to a statement as an expression of opinion unless the writer included all the background facts in the article which the particular judge considering the case believed was necessary to support that conclusion. We agree with petitioner that that is unconstitutional under the Miami Herald test set forth by this court. Therefore, we proposed an alternative test to justify the result of the Court of Appeals.
Oh, so you feel the same way that your opponents do about the hypothetical that I gave about the murderer? That the addition of facts doesn't make the difference?
The addition of facts in that particular case, Your Honor, under the verifiable message test would still, if that was all we knew...
I don't care whether you call it a verifiable methods test or anything. It just seems to me, one thing if somebody comes up to me and says, so-and-so is a murderer, and it's something quite different if somebody comes up to me and says, this woman killed her husband when he went after her with a knife, she's a murderer. You don't think that one is the expression of she's a murderer in the one is an expression of his opinion, that anyone shouldn't do something like that? Whereas in the other case, it's an assertion of something much more factual.
With the underlying facts in the particular instance that you're referring to in the Court of Appeals approach, even under Professor Hermann's test, that would be actionable because even though those facts are set out, the assertion that the person is a murderer sends a further factual message. It sends a message that there was the requisite intent, that it could be interpreted in context as sending the message that the person has been convicted of murder. It is a much closer case, Your Honor, when the underlying facts will affect the message, but in that particular case, even under Professor Hermann's test, that statement would be actionable.
And why does Professor Herman's test violate Miami Herald?
Because Professor Hermann does not look at what the petitioner failed to include, what the writer failed to include in his article. Professor Herman's test looks at what the journalist actually wrote and asks the court to determine what that means and then whether that's verifiable. And under defamation law, the court must always engage in analysis of what something means, or otherwise we can never determine whether it's false or whether it has a defamatory effect. And that is where the approach of Professor Hermann differs from the approach of the Ames Circuit test. Now, context has a number of factors. One must look not only at the exact words of the alleged defamatory statement, but the context of the statement within the entire article in which it appears, the tone, the theme of the article, other statements within that article, and then there's a further context, a broader social context. And the most important element of that broader social context is the level of previous exposure that readers have had to the subject matter of the alleged defamatory article or column, because that will affect how readers interpret particular statements within that column. Now, applying this two-step test to the 5 statements at issue in this case demonstrates that all 5 are actionable statements of fact. The 5 statements can be broken down into 2 categories. The first category purports to tell the reader what Professor Hermann has actually said about himself in his own scholarly article. And the second category purports to tell the reader the level of respect that Professor Hermann's peers within the political science community have for Professor Hermann's scholarly work. Now, this first category, which includes 3 statements, when read in their entire context, communicates to the average reader the message that Professor Hermann has said specific things about himself, that he said that he intends to indoctrinate his students, that he intends to use his class to convert his students to a socialist ideology, and that he is an active proponent of a political ideology called political Marxism. And
isn't political Marxism very akin to the Buckley case charge of fascist?
It would be much more akin to that case, Your Honor, if Alvin Fletcher had simply said, Professor Hermann is a political Marxist. But Alvin Fletcher said that Professor Hermann is an outspoken proponent of political Marxism, and he said so in a context...
Well, how do you distinguish political Marxism from unpolitical Marxism?
Your Honor, it's not important, so important for us to engage in analysis of what political Marxism means. One can interpret the political Marxism in this case as being distinguished from philosophical Marxism as Alvin Fletcher uses it, in that political Marxism is actively trying to indoctrinate students and promoting a social political agenda in the classroom. But the court does not need to engage in that type of analysis.
I would just say, in any event, isn't it obviously unverifiable whether it's political or unpolitical Marxism? How do you verify something like that?
Your Honor, the essence of the message, though, is that Professor Hermann has said that he is a political Marxist, and we can verify what Professor Hermann has said in his scholarly writings by looking at what he has actually written in that scholarly article.
It would be different if he said he was a philosophical Marxist?
Excuse me?
I say it would be different if he called himself a philosophical Marxist as opposed to a political Marxist?
Yes, Your Honor.
Why?
Because in the context of this case, the jury could find that the term political Marxist has a defamatory effect that philosophical Marxist doesn't when used within the context of this column. And it does make a difference to say that someone has actually admitted to being something than to actually than to have Alvin Fletcher come up with this label himself and merely ascribe it to Professor Hermann.
Mr. Field, do we have to go through all 5 of these statements? There are 5 of them. You've barely gotten through one of them. Isn't it enough to find that one should have been allowed to go to the jury? Do we have to...
If the court finds that one should allow...
One's all you need, right?
One's all we need, Your Honor.
So why don't you take your best shot. What's the strongest one?
best shot, Your Honor, is there are two that are basically communicate analogous messages, which are that Professor Hermann has said certain things about himself, that Professor Hermann has said that he intends to indoctrinate students, that he intends to use his course to promote socialism. And in the context of this article, Alvin Fletcher, in the context of Alvin Fletcher's column, Alvin Fletcher introduced the readers to the fact that Professor Hermann had written this scholarly article. And then he labeled that scholarly article candid. And then he said that Professor Hermann's intentions become explicit in this scholarly article. This puts the reader in the frame of mind to expect that they're going to receive a report on what Professor Hermann actually admitted about himself in that scholarly article. And then Alvin Fletcher uses such words as Professor Hermann avows, Professor Hermann concedes, words that further emphasize that Professor Hermann has actually said these things about himself. And because the message is that Professor Hermann has said these things about himself, this is a verifiable message because one can look at what Professor Hermann wrote in his scholarly article and compare it to what Alvin Fletcher said he wrote in the scholarly article. And a jury can determine whether Alvin Fletcher's account is an accurate or inaccurate account.
Isn't all that Mr. Fletcher said, as your opponent said, just exaggerated rhetoric, called about the ponderous tome and adoration of the master? Pamphleteering is hooted at by political scientists. Wasn't the tone of the entire article, if you take it in context, simply one of rhetoric?
Your Honor, we do not deny that this column expressed opinion and that those words demonstrated to readers that there was going to be opinion in this column. But not all opinion pieces, not everything on an editorial page, not all columns contain only opinion. The readers will notice that it contains some opinion, but not that it's devoid of fact. And if one looks at the editorial page or the op-ed page of any newspaper, there are going to be presentations of some facts among the opinion. And in the particular context, especially when Alvin Fletcher says Professor Hermann's intentions are going to are explicit in this article, and then Alvin Fletcher uses these words, the reader expects a factual message. We're not saying that the column is devoid of opinion. It certainly has opinion, and the main opinion is that Alvin Fletcher, there's a serious question about whether Professor Hermann should be the head of the Department of Politics and Government at the University of Ames.
And the main facts are, as distinguished from the opinions?
The facts are that Professor Hermann said certain things about himself, and that Professor Hermann's peers within the political science establishment have a certain level of respect for Professor Hermann. Now, that's the second category of statements to which I'll turn to now.
Mr. Friel, what makes something an opinion? I must say I'm very confused at that. What makes something an opinion as opposed to a fact? It's verifiability?
If it is a type of statement that is incapable of being verified by an objective standard. If it's something that our court system could never verify. For example, if I said something is unfair, there's no way to verify that because the definition of unfairness varies by each person. So any attempt by the court system to try to define that or to punish that would be necessarily arbitrary.
Maybe opinion's a bad word. That is opinion the word we're looking. Suppose I come up to you and the same neighbor problem, and I say, in my opinion, your neighbor is a murderer. Is that libelous? Or is that opinion?
Your Honor, if that's all the context you're going to give me to analyze the statement, I would have to say that can be a factual statement. As Judge Friendly in the...
So the fact that I expressed a fact is my opinion. Obviously, every fact that I express is only my perception of what's a fact, right? So it's all my opinion in a way.
Yes,
it really doesn't make any difference whether I preface it by saying, in my opinion, he's a murderer.
Right,
Obviously, when I say he's a murderer, it just means, in my opinion, he's a murderer.
Right, but if the reader would read that as communicating a message that is verifiable, merely placing the words "I think" or "in my opinion" before a statement doesn't necessarily make something an opinion. One has to read it in the entire context, and if one gets the message that this is merely a subjective evaluation, that it has no factual moorings.
Well, aren't you simply taking one possible interpretation of an ambiguous statement and using a rubber stamp saying this is an interpretation of the average reader and therefore it ought to go to the jury? Isn't that what your test comes down to?
It comes down to, is this statement susceptible to a meaning that is objectively verifiable, and if so, it should go to the jury for a trial on the merits.
And that follows as long as you can give it one of many interpretations that suits your yardstick.
But, Your Honor, the key word, it must be a reasonable interpretation, and it's up to the court to determine
But if it's ambiguous, then a jury could give it one of several interpretations, and we would say, generally in reviewing it, that it's reasonable because the jury found it so.
If it is susceptible to a meaning that is objectively verifiable, then yes, that it would have to go to the jury.
How about political activist?
Political activists in this context, Your Honor, the entire statement gives the reader the message, and when read in context, that Professor Hermann's scholarly abilities are not...
You say that political activist is the antithesis of a respected scholar.
In context...
Suppose perish the thought someone should say about someone that he's a judicial activist.
Your Honor, in this particular case, Alvin Fletcher has made the statement that the statement to the effect that contrary to press reports that Professor Hermann is a respected scholar, he's viewed as nothing more than a political activist. We're saying that when we read the entire context, by juxtaposing and contrasting the terms respected scholar with political activist, the message that's being sent to the reader is that political activist is the antithesis of respected scholar. And so throughout the column, when the term political activist is used, that's the image that's going to be with the reader. That's the image that they are going to get when they read that word.
What if a mayor says that someone is associating with well-known Nazi criminals? Is that fact or opinion?
If the mayor says that...
A mayor of a local town says plaintiff is associating with well-known Nazi criminals.
Your Honor, I want to emphasize that the court must examine the entire context, but an attempt to answer your question based on just that statement, that would be actionable under this test. Now, you may be referring to the
recent opinion in the distinguished Ninth Circuit
by
Judge Kennedy,
correct, Your Honor.
Koch versus Goldway, who held it was not, held it was opinion. It was in the nature of a political slur.
But in the actual facts in that case was that the mayor said there was this noted Nazi war criminal named Ilse Koch, I believe that was the name. And my opponent in this race, her name is Ilse Koch. Are they the same person? Now, the court found that in the context of this particular situation, it was a heated political debate. The audience that heard this statement knew both people and knew that the woman named Ilse Koch at the time was about 42 years old and during World War II could not possibly have been, she would have been 1 or 2 years old at the most. She could not possibly be this war criminal, so that the readers would take that as hyperbole and not communicating a statement of fact.
Mr. Freeland, you got hit with a zinger at the end there, so we let you go overtime, but I think your time has expired.
Thank you, Your Honor.
I will show that Professor Hermann was not a limited-purpose public figure in this case. Therefore, the First Amendment does not require that he show actual malice to prevail at trial, and summary judgment on that ground must be denied. To prove that Professor Hermann is a limited-purpose public figure, as the Supreme Court defined that term in Gertz, Mr. Fletcher must prove that Professor Hermann thrust himself to the forefront of a particular public controversy in order to influence the resolution of the issues involved. This definition has two components. First, there must be a clearly defined controversy. And second, the plaintiff must have engaged in voluntary public activity directed toward influencing the outcome of that controversy. Mr. Fletcher has been unable to prove either element in this case.
Let me ask about the clearly defined controversy. Does this mean a controversy between whom? For instance, isn't there a controversy existing as to whether academics seek to indoctrinate their students, particularly Marxist professors? Isn't that a continuing controversy in our society?
That's certainly a continuing public concern, but the Gertz Court and later Supreme Court decisions have emphasized that a public concern is not necessarily a public controversy.
I recognize that, but suppose that Mr. Fletcher is the first to comment upon this controversy. He's not protected, but the second person is. How does that work?
When a newspaper writer brings something that is not a controversy to public attention, and when it takes someone's writings, someone who has not written in the public sphere, someone's writings that are not accessible, are not available and known to the public, and brings them to the public sphere, and that person is not otherwise a public figure, the person who wrote those things, then that newspaper writer should be held to a higher level of responsibility. The Hutchinson Court
Let me just ask, does the controversy begin then with Mr. Fletcher? And let's assume a Mr. Jones comes after Mr. Fletcher. Mr. Jones now writes about what Mr. Fletcher wrote about, and Mr. Fletcher created the controversy, began it, let us say. Then is Mr. Jones as protected as Mr. Fletcher?
Mr. Fletcher's article alone might not be enough evidence for the court to find that there was a controversy, but assuming the court did believe that after Mr. Fletcher's article there was a controversy, yes, it is possible for a later writer, because in this case, bringing it down to these people, if Mr. Fletcher writes an article and a controversy arises about the subject about Professor Hermann, then for purposes of later comment, Professor Hermann is more like a public figure. He may become a public figure because he responds or because he begins to engage public attention. And because of all those facts, because the public is engaged in more of a controversy and more of a debate and a dispute, then it's reasonable to hold the later writer to a
But what in your hypothetical has Professor Hermann done to change this into a controversy?
Professor Hermann or Mr. Fletcher?
Professor Hermann.
We're arguing that Professor Hermann has done nothing to make this a controversy, that his...
Well, I thought you were suggesting a minute ago that he might subsequently, by responding to the third or the fourth article, and I was trying to understand what your argument was there.
Okay, if he merely responds to Mr. Fletcher's article, as he did, the Hutchinson Court found that a response to someone's defamatory article does not necessarily constitute thrusting. But if instead Professor Hermann wrote further articles or made public comments voluntarily, that might constitute enough thrusting to make him a public figure for later purposes. But at this point...
Didn't the Gertz Court suggest that a public figure could be someone who was drawn into a particular public controversy?
Yes, the Gertz Court did say that, but the Gertz Court emphasized that this involuntary type of public figure would be exceedingly rare, and that it should be seen as an exception to the limited purpose public figure definition where there was both a controversy and public thrusting by the plaintiff. Under our analysis, an involuntary public figure would never exist unless the controversy had reached such proportions that the person involved would necessarily be known to the people because so much had been said, or because the controversy was so raging that it becomes irrelevant whether the person has thrust himself. But in this case, there was no controversy that reached that level.
Well, he had expressed radical views. He had applied for a position of importance at a state university, which might or might not involve policy making. He had run for an office twice, stating his express purpose in getting elected was to make sure that Marxism was taught in the classrooms. How does this keep him out of the public eye?
His activities, his scholarly writings, and his running for a seat in the Council of American Political Science Association were all directed to the profession. And he may have been a public figure within the profession, but in this case, Mr. Fletcher's article reached the readership of major newspapers across the United States, which is not limited to the scholarly academic audience which received Professor Hermann's thrusting.
But it was on the op-ed page, was it not?
Yes.
Isn't that more likely to mean an opinion is being expressed?
For purposes of whether he's a public figure, the opinion question is separate from the question of whether he's a public figure. If something's opinion, it is protected. But here we're looking at whether Professor Hermann is a public
Well,
figure.
how public he becomes depends on how many people know about him. Isn't that correct?
That's true.
And it depends on if a syndicated columnist is writing about somebody, it's because that syndicated columnist believes that that person is of interest to the broad public.
Certainly that's true, but even if that columnist is extremely convinced that that person would be of interest to the broad public, he doesn't have a right to present that person's views to the public in a negligent way. If Professor Hermann is not a public figure at the time Mr. Fletcher decides that his views are so controversial and so important that they should be brought to the public's attention, he doesn't have the right to take Professor Hermann's words and report them in a way that is not true. And it doesn't further public debate for him to present those views in a light in which Professor Hermann never wrote.
Ms. Schott, what do we have to decide about this thrusting controversy for purposes of summary judgment? We make the final determination whether he was thrusting himself upon public attention or not, or do we just decide whether it's at least an arguable point, and if it is, the jury determines it? There's certainly a lot of factual content to that, isn't there?
This is a question of law. There is fact involved, but it is a question of law that must be determined by the court. The court determines whether the plaintiff is a public figure.
We have to decide it all at the summary judgment stage.
Yes. Or if it's not raised at that point, it could be decided by the trial court on
You've
instructions.
converted summary judgment into a full-dress trial, and everybody has to put in all the evidence possible on the thrusting point. And I suppose that's the same thing about the opinion point. We have to make the final decision. Not only do we have to make it, but we have to make it before trial at summary judgment, on opinion as well.
Because this is a question of law, this is a point that if Professor Hermann cannot prove actual malice, summary judgment should be granted. If he's a public figure and he can't prove actual malice, summary judgment will be granted, and it's a way for the defendant to get this out of court.
Well, I know, but normally you only throw it out at summary judgment if it's clear, and if it's not clear, you reserve the question, wait till all the evidence in, and at that point, albeit it's still a question of law, at that point, we'll say yes or no. But why do we have to convert accelerate the whole trial to the summary judgment stage on these points?
Because this is a defense, the question of whether a plaintiff is a public figure or not has to be decided by the court at some point or another. And if the defendant wants to raise it at summary judgment stage, then the defendant has to introduce the evidence that's necessary to decide that point.
No, normally in summary judgment you don't. He just has to introduce enough evidence that's necessary to show that there's a real controversy about the point, that a reasonable jury, a reasonable fact finder could find one way or another. Why don't we just leave the rest of it to the trial and say, let's see what comes in. There's time enough, and we'll throw it out after the trial if indeed there's not enough evidence. But otherwise, you're destroying the value of summary judgment. You're making a summary judgment into a mini trial, aren't you?
But the value of summary judgment here is to protect the press from having to defend these cases at all. And if we're going to require the the defendant to wait until trial to determine whether this person's a public figure, then the value of being able to get things completely out of court because the plaintiff can't prove actual malice.
It's true, but what I'm
would be
suggesting
lost.
is the value of summary judgment isn't very great if the summary judgment is converted into a trial.
But here there wouldn't be that much more that would come out at trial. Here we have affidavits and we have evidence in the newspaper articles. There's ample evidence here for the court to decide whether whether Professor Hermann's activities rise to the level of being a public thrusting and whether a public controversy
Okay,
existed.
I just want to know what you're saying. You're saying that all the evidence that both sides have on the thrusting point and on the opinion point, all of that has to be brought forward at summary judgment, at the summary
At
judgment.
least enough to show that there was a public controversy or that there was public thrusting.
Not at least enough. You better get it all in then, because the issue is going to be decided then, you're saying, right?
Yes, but if there is a myriad of evidence that the person is a public figure, the defendant wouldn't have to introduce every shred of evidence that was possibly available if it was so clear.
Just enough to
without
win,
every-
yeah.
Yes. Enough
But
to convince
not
the
just
court-
enough to make an issue, enough to win.
Enough for the court to be convinced that the person was a public figure.
Strange summary judgment, I think.
The defendant has not proven that Professor Hermann thrust himself to the forefront of any controversy in order to gain public acceptance of his views. As I've discussed, the defendant has not identified any public controversy in this case. But thrusting has no meaning in such a situation where there is no pre-existing public controversy into which a person can thrust himself. Even if there had been a public controversy, Professor Hermann's activities would not be sufficient to satisfy the public thrusting requirement of Gertz. Professor Hermann made no effort at any time to gain public support for his nomination. His other activities were directed toward an academic audience, and even his article, which the defendant has relied on to say that he made an issue of what he would do if he was nominated to this post, it doesn't say anything about that he wants to use a post in higher education, as a chairman of a higher education university to promote indoctrination, as the defendant wants to argue.
If I'm drafted for a presidential nomination, I am not a public figure, is that it? Because I have taken no action on my own. It's been thrust upon me, as opposed to my thrusting myself.
Well, it's unlikely that you're going to be drafted for a presidential nomination.
I'm sorry about that.
Uh-oh.
Let me rephrase that.
Unkind of you to say so, Ms. Shaw.
If you're not already a public figure, it is unlikely that you will be drafted as a presidential nominee. If you already are a public figure, the fact that you've been drafted rather than actually saying, I want to be president, and instead someone else saying, we want you to be president, won't make the difference.
But you're saying it makes the difference here. You laid great stress on the fact that he didn't run for this office, but rather it was offered to him.
If he had been involved in sufficient public activities to make him a public figure apart from this nomination, then the point is he wasn't involved, he hadn't done enough public thrusting besides, and he didn't do anything public to gain this nomination. And what the court should look for is public activities directed toward the public which receives the defamatory article in the case at hand.
You're saying whatever activities he did was directed to the academic community.
Exactly. The Supreme Court has traditionally refrained from holdings which would automatically transform all members of a particular profession or all persons that engage in a particular public activity into public figures, virtually irrespective of their individual activities within that group. That's because we don't want to deter people from engaging in socially valuable activities for doing things which are typical of particular professions. In this case, if Professor Hermann is held to be a public figure, academic freedom will be jeopardized because Professor Hermann has done no more than any other professor, no more public activity than any other professor, and that would be dangerous in making it likely that all other professors could be held public figures.
Should all academics be privileged to make statements that they wish to make in the classroom without fear of suit for defamation? I mean, without fear of being labeled something which would cause them to bring a suit for defamation.
Certainly, if they're only speaking in the classroom, they should be able to speak freely and not have to worry. The court has stressed in past cases that even an indirect burden on academic freedom is a dangerous burden, and we want to encourage the free expression of even minority ideas without putting a special burden on that by some kind of law.
And whether it's a state university or a private university.
Yes, exactly.
He's certainly not limiting himself to the classroom here.
No, but his activities were directed toward the academic community rather than the entire public. If Mr. Fletcher's column had been published within the same academic journal or a similar academic journal where Professor Hermann had previously written, this would be a very different case. But here, Mr. Fletcher took Professor Hermann's views, which were, before that time, limited to being available to the profession, at least generally available only to the profession. And Mr. Fletcher brought those views to the public's attention in a false way. Mr. Fletcher said that Professor Hermann's goals are to indoctrinate students and all these things that we're claiming are false. And if he's allowed to do that, then anything that any other professor writes could also be brought to the public's attention in a way that is negligently false. And that would create a burden on academic freedom, which shouldn't be tolerated by this court. I see my time is up. Thank you.
Mr. Gerber?
Your Honor, we've reserved 3 minutes for rebuttal, so I'd just like to make a few quick points. First, respondents demand that there be public opposition here before we have a public controversy in this case. And as Justice Nelson has pointed out, that would seem ridiculous in the case where the first person, Mr. Fletcher, is to be held to a standard of negligence, for example, whereas the next person to come along would then have the protection of actual malice. This isn't going to just deter Mr. Fletcher from publishing his opinions on this nomination. It's going to deter anybody that's going to publicly oppose this nomination. Now, respondents are concerned about academic freedom here. It seems to me...
All what deters them from is writing something that's false. I mean, bear in mind, they're always safe if they tell the truth, right? I mean, we start with that.
That's correct.
All right.
To the extent that the requisite degree of fault here changes, though, depending on whether the person's the first one or whether the person is the third one. And that fault can protect, an actual malice standard can protect even false statements of fact, because we've decided, this court has decided in the New York Times and in Gertz, that we have to overprotect to make sure we protect all true speech.
If we decide that your client made false statements, we don't have to worry about the second and third and fourth and fifth person who might have done so.
Well, we must decide this case. That's correct, Your Honor. But in doing so, we want to make sure that in other public controversies, in this public controversy, if it continues to rage, we don't want to deter other people from speaking out on an issue that may be of public concern, of political speech, as it's been characterized. We have to keep that concern in mind.
What about the first person that makes somebody a public figure? I mean, I write the first article about Buffalo Bill, and I make him a national figure. And I might say some defamatory things then, and I wouldn't have the protection. But once I've made him a national figure, anybody else would have the protection. And you're saying that's an evil.
That's an evil to the extent that it would deter you from publishing that opinion about Buffalo Bill.
So what's your solution for that evil? Eliminating the public figure doctrine?
No, Your Honor. We'd like to treat the public figure category such that it doesn't demand that there be public opposition, but only public discussion on a matter of public concern that has an impact on a wide variety of people. Public discussion should be sufficient, and we have that in this case. Contrary to
even if you've created the public discussion yourself?
We don't assert that we've created that public discussion, Your Honor. There are, on the record, news articles both in the university community and in the city of Ames.
What about the people that wrote those articles?
Those people were possibly under the threat of being sued for libel under a different standard.
You just don't want to be first. You don't have any objection to having a first and a second. You just don't want to be the first.
That's exactly right, and no one will want to.
That's a different point.
Well, contrary to the respondent's assertion, academics don't publish their views not expecting to get a critique of them. Professor Hermann here, there could be no worse fate for an academic, as we all know, than to have her views ignored. And Professor Hermann has to take the bitter with the sweet when he comes out in published articles and advocates this use of the classroom, this use of authority, as some of his peers and colleagues see it, to transform ideologies. That's of concern. And that's something that his political speech, as Justice Nelson has pointed out, that we ought to be concerned about and ought to not disfavor people like Mr. Fletcher commenting on. And I've also, my time is out, so I will just end there. Thank you.
Thank you, counsel.
Court will be in recess.
The justices have come to a decision, and once again, I'd remind you that we are having reception afterwards in the John Chipman Gray Room on the second floor of Pound, and we'd invite you all to attend. Thank you.
All rise.
Well, there's a division in practice in these moot courts as to whether you make comments first and then announce the decision, or announce the decision first and then make the comments. I belong to the don't keep them in suspense school. So the decision of the court is as follows. The best argument, in our view, was by Mr. Friel. The best brief was the respondents. Both of those votes were unanimous. The best team, by a split vote of 2-1, was the petitioners. Each of the justices will have a few comments about this argument and things in general, beginning with Justice Ervin.
Thank you, sir. I have said this before, and I've been accused of saying it when I should not have, but I don't think I have ever done that, and I'm certainly not doing it here. We were talking, or Justice Scalia was talking this afternoon about the quality of lawyering. It has been my experience, and it was certainly borne out here tonight, that the quality of the oral presentations to this court and the quality of the briefs was certainly far superior to the overall quality of the lawyering that I see sitting in Richmond on a month-to-month basis, and I commend all of you. I thought that by and large you answered questions directly and squarely. Please remember that ordinarily a judge's purpose in asking questions, despite what the conventional wisdom may be, is not to try to trap somebody or to trip them up or to make them look bad. It's to try to find out about some aspect of the case that is troubling that judge. And when a judge asks you a question in oral argument, it's a golden opportunity to sell him on the validity of your side of the case, or to get him to see more clearly your point of view, or to remove from his mind some troubling issue that he's been bothered about. So welcome those questions and answer them honestly and straightforwardly. I've enjoyed being with my distinguished colleagues, and I commend all four of you for jobs well done. Thank you.
Justice Nelson.
I concur in everything said by Judge Ervin. I'm an old law school dean, so I've seen many moot court competitions. I think the participants here rank among the very best I have ever seen, and it was a pleasure to read the briefs and to listen to the arguments. I was especially gratified when no one responded to me as in the last moot court, "That's a good question, Judge." Because as Judge Ervin says, we're asking questions because we truly want to know the answers. And one of the things that lawyers often don't realize is that although you're given 15 minutes a person, you don't have to tell us everything that you've always wanted to tell us in those 15 minutes. You should use those 15 minutes to answer our questions so that we will be sure that we know what your arguments are. But you had the privilege here of being with Justice Scalia and Judge Ervin, two of the finest moot court judges I have ever observed, and so I give them high marks as well. Thank you.
Well, you won't believe this until you've been out in practice a bit, but the performance that you've seen this evening is not at all different from what you will see in an appellate court, even a federal appellate court. The differences are very slight and have nothing to do with the quality of the counsel. This argument would do credit to any court that I've sat on. The one difference that does exist is that very often the court will not let you go on at great length about the facts. That's useful in an exercise like this so that the audience can know what the case is, but very often the presiding judge will just say, "Counsel, we know the facts, get right down to the argument." Indeed, if the presiding judge doesn't say that, you should probably do it yourself and don't waste your 15 minutes or half an hour, whatever the time is, reciting the facts. If the court doesn't know the facts, you're in big trouble anyway. The other advice I always give about the process of oral argument, and again, this may be a slight difference in the moot court situation, although I don't think so. It should be very evident to everyone here this evening that once counsel opens his or her mouth, what happens for the rest of that argument is not within the control of counsel. It's entirely within the control of the court. If they happen to get tickled about a particular point, you may end up the entire rest of your argument on that point. And for that reason, when you're arguing a case, you should never mind what the logical order of your presentation is. Put your strongest point first, because if you're going to spend your whole half hour on one point, you want it to be on your strongest point and not on your opponent's strongest point. So, sound organization, forget about it. Put your big point up front. I agree with the comments that have been made, in particular about the responsiveness of counsel. The worst thing the thing I most hate to hear at oral argument is when one puts a hypothetical to counsel. I don't know where they've been trained to say this, but I have heard so often, "Well, that's not this case." Well, I know it's not this case. That's why I want to know where the principle that you're espousing will lead to in the next case that we have to decide under the same principle. So you're not telling me anything. Be responsive, and I think all of the advocates here today were that way and tried to seize the opportunity to meet the concerns that the court expressed. I thought it was a fine job on the part of everyone, and it was a great pleasure to take part in it. Thank you.